All right, the time has come. Let's get back into court in Florida. 69-year-old Richard Ferguson faces 4 counts of manslaughter for a deadly car crash. But Ferguson wasn't even in the car. Prosecutors say that Ferguson allowed his unlicensed 15-year-old son to drive his car, ultimately leading to that deadly crash. Let's go back into court now. The state is going to give their rebuttal closing, and then we're going to hear the jury's verdict.
Ladies and gentlemen, nowhere in the jury instructions is the state required to prove why Mr. Ferguson decided to let his son drive that day. And the jury instructions also tell you that you should not make your decision based on sympathy for any of the parties in this case. And so comments such as people having prayers or being remorseful are not evidence in this case. Defense counsel kept repeating that Mr. Ferguson never gave his son permission to drive the car, and that none of the witnesses who testified heard him give permission. They all told you, all 3 of them, Janet and Anthony and Elijah, told them that Richard Ferguson had permission to drive that car. And they told you what they saw, witnessed, heard, to let them to believe that. Mr. Ferguson came out to the driveway with them. He saw them load in the car, told them to buckle up, told them to come right back. Those are things that, from context, that people do when you give your son permission to take the car. And let's be clear, telling Richard and his friends to buckle up is not a defense in this case. That doesn't absolve him of the culpable negligence of putting his unlicensed child in that car with 3 other children and sending him out on the roadway. Especially, and you can believe some or all of the testimony in this case, and Mr. Ferguson, not all of his testimony was incredible. He testified just like everyone else did. Anthony, Richard, Jaden, and Elijah were all at the house. That they all asked to go, that they needed to go to Elijah's house for Elijah to get a belt. So we know he's admitted that part of the story is true, but the part that he doesn't want to be true is the part that he's denied. And that's what everybody else is saying, that he gave permission to his son to drive. That he knew his son was unlicensed, and Mr. Ferguson was very evasive in his answers. He kept kind of switching it up when confronted with his own answers. But we know from the 3 children, we know from Michelle Torres, that he gave his son permission to drive. Michelle Torres heard him admonish his son for not doing as was instructed. She did not hear him admonish him for stealing the car, and we know he didn't steal the car because Mr. Ferguson didn't act like his son stole the car. He didn't call 911. He was literally in a vehicle that he had just moved out of the driveway when supposedly his son stole the other vehicle right out in front of him. He knew where Elijah's house was. He could have driven behind him in addition to calling him. The children all testified. We stopped at Elijah's house. We stopped at Anthony's house. We stopped at Deerwood Park. 3 opportunities where if Mr. Ferguson really thought his son had stolen the car, could have intervened either by confronting them himself with his other vehicle, which he was able to get to the scene pretty quickly after the fact, but he didn't do anything that you would expect one to do when your son, who has no permission to drive, has no experience driving, has just stolen your car. There is no credible evidence in this case that suggests anything other than the defendant gave his son permission to drive the car, let him go on the public roadways where there are other drivers, putting Richard and his passengers at risk, the driving public at risk, and ultimately resulting in the deaths of Anayari Hernandez-Marcillo, Trinidad Hernandez, Marvin Cruz, and Miley Cruz. When you review the evidence, you will find that he is guilty beyond a reasonable doubt.
Members of the jury, the court's been made aware that you have reached a verdict. Who is our foreperson?
Yes, sir.
Mr. Foreperson, has the jury reached a unanimous verdict?
Yes, sir.
If you'll please give the verdict forms to the court deputy. with counsel.
In the Circuit Court of the 9th Judicial Circuit and in Fort Osceola County, Florida, case number 49-2025 CF 507, State of Florida versus Richard Seymour Ferguson. As to the verdict for count 1, we the jury find the defendant guilty of count 1 manslaughter. As to count 2, we the jury find the defendant guilty of count 2 manslaughter. As to count 3, we the jury find the defendant guilty of count 3 manslaughter. As to count 4, we the jury find the defendant guilty of count 4 manslaughter. So say we all, dated at Kissimmee, Osceola County, Florida, on this 29th day of October 2025, signed by the foreperson.
You may be seated. Does either side wish for the jury to be polled by juror badge number?
Yes, sir.
Madam Clerk.
Juror number 62, are these your verdicts?
Yes.
Juror number 20, are these your verdicts?
Yes, ma'am.
Juror number 34, are these your verdicts?
Yes.
Juror number 97, are these your verdicts?
Yes.
Juror number 155, are these your verdicts?
Yes.
Juror number 107, are these your verdicts?
Yes.
The jurors are unanimous.
All right, so Ferguson found guilty on all counts. Apparently, it took the jury just 2 hours to come to that conclusion. Let's bring back in our guest. Still with us this hour, former law enforcement officer Claudia King and attorney Rob Corbett. Rob, I want to begin with you. Get your reaction to the verdict.
I think the verdict is appropriate, and first I always tend to lean on the side of whatever the verdict is. I always think that is the appropriate result because I believe in the jury process. But regarding the evidence that was presented during the course of this trial, the prosecution, especially in the rebuttal, laid out in terms of the facts of their case. And if you had any concern, if he honestly thought that his son had taken the car without permission, in the rebuttal, the prosecutor indicated or laid out that he didn't take any action to try to alleviate that, to try to see if your son took the car, why didn't you at least try to call your son, tell him to come back home, or you knew where he was going to go. So based on what was presented, then I do agree that that was the appropriate result for that jury to reach in this trial.
Yeah, Claudia King, I want to get your reaction, but also, you know, we see this trend now where parents are, again, as I mentioned, being charged in response to what their children do. I don't think this particular case is part of a trend. I think whether this case took place today, 10 years ago, 20 years ago, this is the kind of case that would have been prosecuted.
Yeah, I agree with you, Michael, and I do agree with the verdict as well. I think the evidence was very clear that this was the appropriate thing to do, that he did give permission, and he did not do anything to try to stop his son had he not given him permission. But I also agree that I don't think this is part of kind of the newer trend, as you mentioned earlier, with school shootings and things like that. This is something that's been going on for quite some time, and I think it's one where the law has been easier to prove, and it's been easier to bring this kind of trial and bring these parents to justice on this, because it's something that we're all familiar with, and it's not a gun was locked away, you know, we didn't know he had access to it. This is more clear where he didn't hand him the keys, but he handed him this multi-ton vehicle and said, go on, do what you're going to do.
Yeah, no doubt about it. And Rob, he's facing 37 years to life under these circumstances. What we know is that the son pleaded guilty. He didn't testify in this case, but he pleaded guilty. He will be under juvenile supervision to the age of 19, which is probably about 3 or 4 years, and then he'll have 2 years probation after that. Yet the father facing 37 to life. What do you think the sentence might be? And do you have an issue with that sort of difference between the punishments in this case?
Not so much a difference between the punishment in that the son accepted responsibility based on the son's age. That's taken into account as well. Now, in terms of what is a possible sentence, the defendant, 68 years old. So the argument is that whatever sentence he's going to receive is, in essence, going to be a life sentence. I can see in terms of the judge consolidating all 4 into one judgment of manslaughter, but that sentence is going to be at the high end, and it's going to result, in this case, into a life sentence.
Quickly, Claudia, I have about 20 seconds here. He does face 15 years on each count of manslaughter. There were 4 counts. What do you suspect this sentence might be?
Yeah, I think whatever it is, it will be a life sentence. I think it's going to be more than the son because he didn't take responsibility. He went to trial and it didn't work out for him. So unfortunately, I think he's going in for life.
Yeah, and that may be the case because my understanding is, I haven't verified this, he has stage 4 pancreatic cancer. So I heard that as well. All right.